All right, we're back on the record and we've got people, the Tristan Long, file 25-6997FH. Counsel, you want to state your appearance, please?
Dusky on behalf of Mr. Long.
All right, so we have we had on the docket today Mr. Kukuski's motion to withdraw as counsel for Mr. Long, given his decision to absent himself from this case. And there was a pending warrant for his arrest. Looks like he's been taken into custody and we have him here today. So we probably need to arraign him on that warrant. But I guess, Mr. Kukuski, where does that leave you with your motion?
Well, at this time, Your Honor, I'd still be moving forward with my motion because I did contemplate having the court maybe move it a week since now I am able to communicate with him and see where he's at. I wasn't sure if there was an additional absconding charges or what was going on there, but I did feel that there was a breakdown in our communication relationship such that my representation to continue as counsel would not be advantageous here and beneficial. There's no, the relationship had broken down to that extent. So.
Okay, I do have a docket next week if you wanted me to do that, but you want to have the motion heard right now then?
I think, yeah, I do. Okay. I think it makes sense to move forward with the motion today, and then I can discuss things with the prosecutor. But I just again would like to have a motion heard.
All right, Mr. Juliet, do people have any position for her?
No, Your Honor.
Mr. Long, do you want to be heard on that question? Mr. Kukuski believes that you and he were not communicating to the extent that he's no longer able to serve as your attorney. Do you have any disagreement with that? Or?
No, sir. I apologize.
All right, I'm going to grant counsel's motion to withdraw, and I've signed the proposed order discharging Mr. Kukuski from further representation in the matter. We had a bond forfeiture hearing later this afternoon that'll be canceled. I did already sign the proposed order from the surety company. But we do have, when were you taken into custody, Mr. Long?
Yesterday.
Okay. I think what I'm going to do then, we would prefer to take care of it all today, but with Mr. Kukuski being discharged, I'd want to have you have an opportunity to speak with assigned counsel before we arraign you on the pending warrant. So we'll just arraign Mr. Long on the other matters tomorrow. And so tomorrow we're going to bring you out and arraign you on the warrants. Then you can talk with the Office of Assigned Counsel. Okay.
Sorry, I did talk with somebody from the assigned counsel, and he said he would step in.
Who's that?
Would have been Mr. Nightingale.
Mr. Nightingale. Yeah. All right. Well, if Mr. Nightingale wants us to call the case this afternoon, we can do that. But otherwise, we'll just arraign Mr. Long tomorrow. I don't want to arraign him without an attorney here. There is a child support warrant though that I can arraign you on. In Price v. Long, file 2017-12113DS. It's alleged that you're in contempt of court for failing to pay support as ordered and failing to appear. You have the right to have a hearing on that and the right to counsel if you can't afford and request counsel. The court would appoint counsel for you. That's not through the MIDC office. It's through a different list. If I find you in contempt, I can place you on supervision with the friend of the court office, can fine you, can jail you for up to 45 days if it's your first contempt, or up to 90 days if it's not your first contempt, can suspend your driver's license or other occupational licenses that you have. Mr. Ortiz, you want to update us on the status on the child support matter?
Yes, sir. I'll just come to the podium.
Okay.
Your Honor, my records reflect on August 22nd, 2025, Mr. Long failed to appear before the referee, has failed to make payments. A bench warrant issued with a $4,000 bond. Since that date, we've only received 2 payments. In all of 2025, we've only received $666.95. This case charges at $327 per month. Arrears currently sit at $16,526.39. There has been 4 bench warrants previously issued in this matter, 1 finding of contempt. He was placed on supervision previously for 30 days. He did serve 2 of those days, with supervision being somewhat successful with payments.
All right, so Mr. Long, how do you want to proceed on the child support contempt? Do you want me to appoint an attorney for you? Do you want me to set up for hearing? Do you want to plead guilty to contempt in the child support matter, or what do you want to do?
I'll plead guilty. I haven't paid in a minute and I understand that I owe.
Okay,
I just,
okay, you understand the rights that I outlined for you? Has anybody promised you anything in exchange for your plea? Has anybody threatened you?
no, sir.
All right, and so you acknowledge that you have failed to pay child support as ordered?
Yes, sir.
All right, I'll accept that plea, find it to be knowingly, understandingly, and voluntarily made, and I will find you in contempt. Mr. Ortiz as to sanction.
Yes, Your Honor. Given the circumstances here, I'd ask that Mr. Long be placed on supervision for a period of 1 year. However, that those terms be that I don't know if or when he'll be released, that upon his release from incarceration, he immediately notify the friend of the court, he update his address with us, that will monitor payments, given the circumstances, at least that monthly amount of $327, and that he be sentenced to 45 days. And we can.
Okay. All right, Mr. Long. 45 days now, or?
I would suggest we hold it in abeyance pending his release.
All right, Mr. Long, anything you want to tell me about what we ought to do with the child support matter?
No, sir, I do take care of my kids. I have them, well, one of them, I have 50% of the time. I do feed him, put clothes on his back. I mean, I do need to do way better at providing for him in that matter, so I do apologize.
All right, well, on some of that, if you keep your friend of the court caseworker informed about what's going on, if there's changes of circumstances of custody, that can affect how much you have to pay per month in child support. So you want to keep them informed about what's going on. What I'll do is this: I'll place you on supervision for a year with the friend of the court office. Order that immediately upon your release from the jail that you would contact the friend of the court office, update them on your residence and employment situation, keep them informed on that. I'll order that you serve 45 days in jail, give you credit for 1 day served. I'll hold the other 44 days over your head for the supervision on the child support, and order that you make a minimum of $400 a month payments. That covers what it charges, plus a little toward the arrears. And so then, Mr. Ortiz, you'll submit an order to that effect?
I will, Your Honor.
Okay, so that'll take care of the child support matter. So you won't be in the jail anymore on the child support matter, but we will arraign you either later today with Mr. Nightingale or tomorrow with the arraignment attorney on the criminal charge, and we'll see where we're going on that. All right.
Yes, sir.
All right, Ms. Elliott, we have sentencing after delay and Mr. Hebwite.
Yes.
All right, this is People v. Grant Hebwite, file 24-6949FH. Counsel, you want to state your appearances?
Liz Elliott on behalf of Grant Hebwite, who sits to my right.
All right, so this is sentencing after a delay period. If you had a chance to review the pre-sentence report and recommendations,
I have, Your Honor, yes.
any additions or corrections?
The only addition or correction I would make is that he's made additional payments since this was drafted. The balance owed right now is $4,854.94.
Okay. The advisory guidelines were scored at 0 to 6. Any challenge to the scoring?
No, Your Honor.
Mr. Juliet, any additions, corrections, or scoring challenges?
No, Your Honor.
Anything you want to say on behalf of your client?
Well, Your Honor, Mr. Hebwite was injured at work in March of 25 and was off work for 2 to 3 months due to that injury. He was seeking other employment. He managed to find work at the local school in September, where he's only working part-time. He does live in a pretty rural area. His job opportunities are very limited due to where he lives. He doesn't have independent transportation of his own, so he's real limited in the amount of money that he can make. He brought pay stubs with him today after he pays his bills, his living expenses. He's got about $50 left to live on. And so we would just ask the court to either allow him some time to continue paying off the restitution, or at the very least, follow the recommendation to just place him on a term of probation and allow him to set up a payment plan for the remainder. Thank you.
Okay, thank you. Mr. Hebwite, you don't have to make a statement today, but you're allowed to. Is there anything you want to tell me, sir?
It's been a rough year with my injury and stuff and trying to find employment. I'm trying really hard, Your Honor, and as I spoke to my attorney and stuff here, I'm willing to do anything it takes right now to correct this, because I mean, I'm just.
Well, all we're asking you to do is pay back money you stole.
Yeah, I know,
So I don't know what you're crying about.
I know, I'm just scared, I'm trying really hard, because
I mean, that's fair, right? You should pay back what you stole.
I understand.
Okay, that's all we want to have happen. Mr. Juliet?
I would ask the court to revoke the delay sentencing on the underlying felony. He was sentenced on January 7th of last year. Minimal amounts of restitution have been made. It looks like they were all made in May of 25, June of 25, and then July. There were small amounts. This is in my mind, a significant term of the delay was to pay back the restitution. It's still owing in a significant amount. Arguably, there should be some sort of jail sentence in this case. It's not being recommended, but the argument could be made. But otherwise, I agree with the recommendation.
All right, thank you, Mr. Hebwite. Please stand for the court sentence. Well, I think I would have to find that the delay was not successful. You didn't comply with the terms of paying back the restitution from the victim from whom you stole several $1,000s. So the prosecutor's not required to reduce the charge to a misdemeanor as they had offered if you had paid the restitution off. But I don't think that, I mean, the guidelines are 0 to 6. There's no prior criminal record for Mr. Hebwite. So I think that the probation recommendation is appropriate, proportionate. So we'll enter judgment now on the felony conviction of larceny by conversion over $1,000. For that conviction, I'll place Mr. Hebwite on probation for 1 year, subject to the terms and conditions listed in the pre-sentence report. Those include the financial assessments that remain due and owing as previously assessed in the amount of any unpaid balance. You have to seek and maintain legitimate employment, and you are eligible for early discharge from probation at the halfway point, Mr. Hebwite, if you've successfully completed the terms. So we're going to hand you a piece of paper explaining that process.
Okay.
And also, if you wanted to appeal, you can do so. If you wanted me to give you a lawyer, I would do so, but you'd have to ask me within 6 months. We're going to hand you a piece of paper explaining that. Ask you to initial 1 copy for us, so we have a record we gave it to you. The other one is for you to fill out if you wish to take an appeal. So just, you're not going to jail today. And so you just continue on probation. The conviction's going to enter though. So continue on probation and set up a payment plan through your probation agent, through the court to get this taken care of. And as soon as you get it taken care of, I'm happy to discharge you from probation. All right, good luck to you. Do you want to stick around to talk with you or not? Oh. Okay.
He does.
Mr. Hebwite, before you go, stop by the probation department.
Yes, sir.
Mr. O'Malley, are you ready with Mr. Hawes? We can get you on the road here. It's Paul Hawes. All right, this is People v. Curtis Hawes, file 25-7062FH for sentencing. Counsel, you want to place your appearances on the record?
Melissa Goodrich, Flint County Prosecutor.
Good afternoon, Your Honor. Michael O'Malley, appearing on behalf of Mr. Hawes, seated to my right. Please state your full name for the record.
Name is Curtis Clark Pause.
All right, good afternoon, sir. Mr. O'Malley, have you had a chance to review the probation or the pre-sentence information report and recommendations with your client?
I have, my client has reviewed it. I've reviewed it with him. There are no material additions, corrections, or deletions to be made.
All right, and the advisory guidelines were scored at 0 to 6 months. Are there any scoring challenges from the defense?
Not from the defense, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
And Mr. O'Malley, anything you'd like to say on your client's behalf?
Your Honor, most of what I would say about my client is actually contained in the report. He's 65 years old, / retired disabled. At this point in time, he noted in there, which I highlighted, of course, is that he's remorseful for his actions, particularly at his age. He pointed out that he had a troubled relationship with one of his daughters, and he's trying to maintain a strong relationship with his other daughter, who's a co-defendant in this case. Obviously not the best of choices, not the best ways to go about that, but I think they both will be learning their lesson from this. The recommendations seem absolutely appropriate. I've gone through them with my clients. He is interested in doing whatever he can to prove to this court that he's not a danger to himself or his community back down in Oakland County where he lives. The only request I would make is I do note that one of the recommendations is that he's to obtain employment due to his age. I would ask the court to discard that recommendation, but otherwise your probation seems appropriate to me.
Okay, thank you. Mr. Hawes, you don't have to make a statement today, but it is allowed. Is there anything you want to tell me, sir, or no? Would you like some hearing assistance to amplify?
Yeah, but I can do that.
All right, Mr. Hawes, you don't have to tell me anything today, but you are allowed to. Is there anything you want to tell me, sir?
I apologize for the county of Sheboygan that I made a bad choice. And I was up here about celebrating my daughter's birthday. This is where she loves to come up to, you know. And yeah, that's about it. I made a bad choice.
Okay. All right, thank you. Ms. Goodrich, any recommendations from the people?
Oh, yes, Your Honor, thank you. The defendant has no prior felonies and just one prior misdemeanor. He was cooperative with law enforcement as well as quickly took responsibility in this case. We have offered a 7411 and the PSI recommendations comported that.
All right, thank you. Mr. Hawes, if you please stand for the court sentence, sir. Mr. Hawes, you don't have any remarkable criminal history. It looks like just a misdemeanor in the past. 66 years of age. This, you know, you've alluded to it, your attorney has, and, you know, it's just a head scratcher for us really here for a dad in his 60s with his adult daughter as part of a celebration and vacation using cocaine together is really a strange thing for all of us to ponder. So, you know, you want to, sounds like you've got to work on your relationship with your daughters, or at least one of them, but there's certainly healthier ways to do that than bonding together through substances. So I hope you find healthier ways to interact with both of your daughters. I do think probation on 7411 is appropriate here, given your lack of record. And that means that if you successfully complete the terms of probation, the charge will be dismissed. There'll be no public record of your conviction. So the court will not enter a judgment of conviction today, just a probation order, and place you on probation under section 7411 of the Public Health Code. During that year of probation, you'll be subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report, including substance abuse treatment as referred by your supervising agent, crime victims assessment of $130, court costs of $350, DNA testing and a $60 fee for that, $68 in state costs. There's a monthly supervision fee, 2 days jail with credit for 2 days served. There's no actual probation term that requires him to be employed, but it is stated in the rehabilitation goals. So can we Who's gonna be a supervisor? Well, it's gonna be transferred down, but can we direct Agent Leskey to remove the employment portion from the rehabilitative goals?
Yeah.
All right, and that'll be the sentence of the court, Mr. Hawes. It's within the guidelines range. It's consistent with the plea agreement. If you wanted to file an appeal, you'd have to do so by filing an application. We're going to hand you a piece of paper about your rights in that regard, ask you to initial one copy for us. Also, you're eligible to request early discharge from probation at the halfway point. If you've completed all its terms, we're going to hand you a piece of paper about that as well. Okay, you have any questions for him? So how do you want him to begin? You want him to stick around, check in with probation across the hall?
Yeah.
Okay, Mr. Hawes, go across the hall when you leave the courtroom to the probation department, okay?
Okay.
All right, good luck, sir.
Procedural thing, Your Honor, obviously the first time I've been in front of you regarding payment of those fines and
Oh,
costs. Is he
yeah.
eligible for a payment plan?
Yes, he can contact circuit court office directly and set up.
Thank you, Your Honor.
Discharge rates, or early discharge rates. Get your initials on this highlighted line right here.
Yeah.
Thank you very much. That's your copy.
Yeah.
All right, thank you, Mr. O'Malley.
Pleasure to meet you, sir.
Thank you, Your Honor.
All right, good luck.